Welcome to Beyond the Law.
Beyond Law Group's podcast that brings you unfiltered conversations
with our lawyers, clients and friends.
We'll be having frank discussions about our experiences in the legal sector,
sharing our thoughts on current topics from a legal and a personal standpoint,
as well as offering our top tips for those pursuing a career in law.
Beyond the Law.
Beyond the Law.
Beyond the Law.
Hello and welcome to a Beyond the Law podcast. My name is Jason Stanley. I'm your host and I'm delighted today to introduce my colleague, Melissa Jones, an associate solicitor at the award-winning McAllister Family Law. Welcome.
Thank you very much for having me.
My pleasure. Today's a celebration because you were involved in two really interesting reported cases that have come back to back almost at the same time.
Yes, 6 months apart.
Fantastic. And they are niche and complicated, and we're going to talk about them in a little bit more detail. But for the listeners and viewers out there, tell us a little bit about you and what your specialisms are and your role in this firm.
Of course, yes. So I am a children's specialist. I have been qualified for 12 years, been doing family law for 15 years, and I specialise in children law. So contact arrangements, who children live with, who they spend time with. And I also have dealt with cases relating to grandparents and their rights too.
Yes, and I think you've touched upon a little topic of debate. We're going to have this later on in this podcast.
Yes.
Well, thank you for that. I'm grateful. But we'll launch straight into these two exciting cases because, correct me, is this your first tranche of reported cases or have you had others before?
These are my first reported cases. And I think somebody was saying that you were lucky to have one in your whole lifetime as a lawyer.
Excellent. Two come along, a bit like buses.
Yes.
Fantastic. Well, let's launch straight into it. So I have had the pleasure of reading the judgments and some of the legal arguments, and some of them were really complicated. But we'll deal with the first one that caught my attention, which is an interesting case about parentage. It sounds an obvious thing, a baby is born and they've got parents, but this had some specific niche elements to it. So just can you give a little bit of background about this particular case? Because my understanding is not a simple case of a child having a biological mother and a father. The couple in question struggled to conceive and they had to involve a more complicated process of a third-party donor. Is that correct?
That's right, yes. But that was abroad. So they had tried it in the UK. That didn't work, unfortunately. So they travelled to Cyprus to do that and therefore used a sperm donor and then came back to register the birth in the UK.
And that's interesting because a birth certificate is a really important document in our field of law, is it not?
It is, yes.
It's the starting point in almost any child dispute of this kind of ilk. So if I've got my facts right, the mother, who's the biological mother, is named on the birth certificate and the non-biological father is named on the birth certificate. Is that correct?
That's right. The mother's partner was named on the birth certificate.
So how did the dispute manifest itself? Why are we even talking about a reported case? How did it become difficult?
There were issues post-separation of the parties in terms of the contact between the non-biological father, so the applicant in that case, and the child. So the father made an application to the court, as you can do, to define the arrangements between him and the child. And of course, within those proceedings, the court needed to be made aware that actually another issue that they needed to decide was the paternity and almost the parentage of this child, and that was a really important part of the case.
Understood, because I didn't understand his case because he's de facto not the biological parent. And so why is there even a debate about it? I think in the judgment I read this was not something controversial as far as the judge was concerned. They spent more time focusing on what a parent actually is rather than fixating on the biological element.
Yes, because in his judgment, he makes the point that the mother's the biological parent.
Of course.
The applicant is not the gestational or genetic parent, and therefore, even with registration on the birth certificate, does not confer parent's responsibility and is not, in fact, the father. So that was the judgment that the judge made, essentially.
Is that why this is reported? Because that helps other clients or people or lawyers in similar scenarios on that discrete point? What was the point about it being reported?
Absolutely, because we, Jason, have many clients probably who would think, oh, well, it's my partner, let's put them on the birth certificate and don't think anything of it. But it has a completely different meaning within the Children Act as it stands and how that impacts parenting and obviously a child's right to know their heritage.
Yes.
So it does have implications, but you're right, in terms of informing the general public, there is a need to do that because it's in the interest of the public to know. Lots of people may be in similar positions, that if you do that, there are implications of that.
Yes.
And that doesn't mean that your partner is then known as the parent of the child, and that child obviously has a right to know.
Indeed, fascinating. Your second reported case, again, I was delighted to read how amazing the judgment was. I was really impressed with the judge, but two key themes that came out of that for me were parental alienation, that I'm finding is a very hot topic at the moment in a lot of the children disputes that I'm dealing with personally, but also the role of a grandparent, which again is a very fascinating area of children law. And again, would you kind of give a bit of an overview for the listeners or those listening to this podcast of some general principles about those two things?
Of course. So within this case really was twofold: equal parenting and the recognition of that, and also contact between a child and their grandparents.
Yeah.
Those were the two keys issues in the case.
And you're quite a big advocate of the grandparents' role with relation to a child, aren't you?
I've worked on many cases relating to grandparents. I have had 2 cases within this firm where we've successfully obtained a special guardianship order for 2 separate grandparents in 2 separate cases, and also a shared care arrangement for a grandparent and then a interim child arrangements order.
And just to develop that a little bit more for the listeners, grandparents do not automatically get any right whatsoever in relation to a child.
No.
It is something that is conferred on first breath to mother and father, and that is it. The court does have the power to award that, like you've just explained, or take it away. But for a grandparent, they don't. Some grandparents may automatically assume, because they were really involved in a grandchild's life, that they have a say in day-to-day or more far-reaching prominent decisions in a child's life. And that's not correct, is it?
It's not correct. They have no automatic rights. They have no parental responsibility, and they therefore would need to make an application to the court for permission to make an application.
And that's what happened in your case, isn't it?
It is, yes.
And you were successful, were you not?
The grandparents were
Yes.
successful, and it was quite an interesting case that they had to make the application in the first place because there was quite a lot of acrimony between both parents, and contact between the grandparents was also limited. So they successfully went on to make their application and have walked away with an order in their favour.
Aren't you worried that this precedent, I'm going to be controversial on purpose, that it sets a precedent for grandparents who might be well-meaning but assume that they have the greater say or a greater input in how a child might be raised, either on a day-to-day basis or far-reaching decisions? Don't you think that this is slightly dangerous, that you're undermining a parent's role in this?
No, because you've got to understand that the court's making a decision at the end of the day, and it has all the facts before it. It had submissions in that case. It had all of the evidence as to why this was needed. It listened to the evidence and made a decision, but it didn't make an order that said, okay, so the children are going to be divided 3 ways. It didn't do that. Mm-hmm. It made a provision for an order for ultimately the grandparents to help out and have their time with the children in accordance with what would typically be what a grandparent would have.
Sure.
So it's not far-reaching. It's nothing like that. It was exactly what the court ordered in that regard.
But you take my point, it could be open to abuse, that you could have quite a controlling grandparent who thinks that they've got the knowledge and the experience to dominate what they perceive might be in the best interests of the child, and it's not for them to say.
It's not for them to say, and parents would agree with that. But that is why you have the additional obstacle at the first application stage, because they don't have automatic rights. Yeah. So I think you will always get that test.
I'm not anti-grandparent, for the record.
Okay.
It's just to sort of explore a rather interesting niche topic about the roles in the sort of modern, certainly some of the law I do, the blended family. You know, you've got perhaps 2 parents who are meeting, having their second relationships, that may be in the sort of middle age. They've got children from different relationships that have not worked out. Grandparents cohabit with their say, daughter and then son-in-law and bring a certain dynamic to it. And I wonder if this is fertile ground for more cases to develop these ideas in the future. Do you see there being more of these moving forward?
There may be. It's possible that there may be more cases like that. But I do think, this may be an unpopular opinion, but I do think grandparents are underused or aren't recognised for the roles that they perhaps do and are used frequently. But perhaps when it comes to a conflict in a case, they're not seen favourably for whatever reason, above and beyond the parents, which is right. They are the parents, but they have the ability to get an order in court, and I think that is their right to do so.
It's amazing how that all of a sudden, during the course of a relationship, grandparents are welcome and wholesome and very much part of maybe even logistics, pickups and drop-offs, and then there's a separation and it becomes very partisan, doesn't it? It
becomes very partisan, but parents rely on grandparents a lot, want to work, to enable them to go to work, for after-school activities, for babysitting, a lot of the time, and the children really do kind of excel within grandparents' care, in some cases. Yeah. So I think they are underused, but parents obviously do come first. That is the principle I think we can agree on. Yes. But there are cases where grandparents are absolutely needed.
Moving slightly off-piste a little bit, in terms of the reporting element to it, did you know this was going to be reported?
The grandparents' case and the parents' case. Yes, towards the end of the case, yes.
So how does it work? Did the judge sort of say, look, the way the landscape of this case is going, I'm tempted to consider this as a reported case? Is that how it unfolded?
Well, the request was made and that was granted, but I think for transparency reasons, it's important that it was published, because we're moving towards more of an open court anyway with the Transparency Project. But the reason that they do publish these cases is to inform the public, to educate, for other probably practitioners to see what is happening in other courts, but also for parents and grandparents, especially in this case, who look at this case and think that's something that has happened to me and I should be informed that these decisions are being made. So I think it was for the right reasons it was published, and you can read the summaries, of course, and I'm sure you have, but they are very clear.
Don't you worry, I'll be quoting your case in some of mine, particularly in those grandparent alienation cases.
Yes.
But from a personal accolade, and it's not the Melissa Jones show, but that must be a huge milestone in your career. You must be so proud.
Yes, I am. Yeah, very proud.
Yeah, and we are of you. And you are now a legal trailblazer. You're creating law or being part of that process to, as I say, help the future generation. Well, thank you for your time. I know you're a very busy practitioner. It's been wonderful listening to some of the anecdotes and having a healthy debate about this particularly relevant and prevalent topic. So, yes, thank you.
Thank you, Jason. Thank you for listening to Beyond the Law. You can find more episodes wherever you find your podcasts.
Thank you for listening to this episode of Beyond the Law.
To keep up to date with all things Beyond, follow us on our socials at Beyond Law Group.
You can tune in to our next episode wherever you find your podcasts.